Good morning. I hope everyone had a wonderful weekend. Maybe got some of those freebies at Kroger Wellness. All right, so we have 4 cases on the docket this morning. 2 are scheduled to argue here in the courtroom. 1 is scheduled to argue via Zoom, and 1 has submitted on the briefs. The first case that we have is case number C230015, which is State of Ohio versus Rainey, and that has submitted on the briefs. The second case we have is C230128, Muhammad versus Chauhan. If the attorneys can please identify themselves and their readiness to proceed.
Yes, Your Honor. Sierra Cousin for appellant.
Michael McIntosh for the appellant.
All right, thank you. Next case is case number C220662, William Chappell versus Wheeler Growth Company et al. If attorneys can please identify themselves and their readiness to proceed.
Hope Potts, I will be appellant.
And Attorney Finney, are you ready to proceed?
Christopher Finney for Mr. Chappell.
All right, thank you. And the last case we have is case number C220500, in re Estate of Ann Catherine Jordan. That case will be argued via Zoom. Okay, Attorney Causey, did I say that right, Causey?
Yes.
Okay, whenever you're ready, you can come up. Would you like to reserve time?
Yes, Your Honor. I'd like to reserve 3 minutes.
Okay. Whenever you're ready, you can start.
Okay. Good morning, Your Honors, and may it please the Court. My name is Sierra Causey, and I represent appellant Renad Muhammad in her appeal denying her and her son, KS, a DVCPO from her husband and the child's father, Amer Chauhan. Today, you will be using the abuse of discretion standard. The abuse of discretion standard is found when the court's attitude is unreasonable, arbitrary, or unconscionable according to Parrish v. Parrish of the Ohio Supreme Court. Ms. Muhammad was married to Mr. Chauhan on October of 2020, and they had their child, KS, born October 10th of 2022. She testified at trial that there were several instances of physical and sexual abuse towards her and the minor child.
Yeah, and so the problem here is that the trial court made credibility findings adverse to your client, and we get a number of domestic dispute cases in a variety of contexts, and many times they are credibility battles between one side saying, he assaulted me, and the other side saying, no, I didn't. And you know, when we have a trial court making credibility findings, we typically defer to that. So why shouldn't we here?
Correct. Your Honor, so I believe that the issues here are very similar to actually Felton v. Felton that the Ohio Supreme Court decided. So in Felton v. Felton, the court was faced with very similar issues where the petitioner testified that they were abused on several instances, and they had very brief testimony from an eyewitness that really just said that they had witnessed and saw bruising on the petitioner at some point. This is very similar to that case, whereas the petitioner in this case testified to several instances of physical and sexual abuse towards her and the minor child, but also presented actual photographs as well.
But she also acknowledged that she had fabricated a photograph.
Correct.
So, like, how is a court supposed to look at photographs in light of that admission and not be skeptical of them?
And I completely understand a court being skeptical of that, but Your Honor, I think it also bolsters her testimony that she wasn't willing to lie on the stand. She wasn't willing to say, no, that wasn't me, I didn't do that, because it would diminish her credibility possibly on those other photos. Additionally, very similar to Durastante versus Durastante, the respondent actually moved for a dismissal after the petitioner had presented her prima facie case, presented her case, and the court found that she had presented her prima facie case. So if the court would have found that she was not credible, if the court had found that she, may not have presented that case, then really the matter should have been dismissed, but it wasn't. The magistrate declined to dismiss it and move forward. However, moving on to,
Couldn't the magistrate have been unsure on credibility at that juncture? And then after the presentation of the defendant, then be able to make that determination of credibility?
absolutely, absolutely. But moving into what the appellee actually said, appellee really didn't add much. Appellee really just answered one-word answers as far as, did you do this? No. There really wasn't any kind of anything added, and honestly, the things that he did say might have actually added to her credibility. For example, there was one instance where we were talking about, he was asked a question about grabbing the petitioner, and he said, well, the first grab, and then he was interrupted by his counsel. Several times, he was interrupted by counsel. Several times he was coached by counsel. Several times the record didn't catch the transcription because this all was.
Were there objections at that moment, at those junctures?
No, there was not.
Okay.
No.
Because you didn't assign error to that.
I'm sorry?
You didn't really assign error to that.
Right, and so there were also times where it was impossible to understand what he was saying because there were just so many things going on at once. And additionally, he was talking over top of the interpreter. So looking back at the record, it's very difficult to actually tell what he said.
Counsel, you began your argument by acknowledging the abuse of discretion standard. Mm-hmm. When there is evidence in the record to support the trial court's credibility finding, how can that ever rise to an abuse of discretion?
Right. So, Your Honor, I think there can be, right? But if you look at especially other court cases and compare it to other court cases like Durastante and Felton v. Felton, I think you can make that abuse of discretion finding.
But have you seen a case in Ohio that has reversed the denial of a protective order under an abuse of discretion standard?
So Felton v. Felton was one of those,
Okay.
yes. Felton v. Felton did reverse it. The court found that there was not, there wasn't the amount of evidence needed to rise to the abuse of discretion, or it wasn't enough evidence to rise to the level of issuing a domestic violence civil protection order, but the Supreme Court actually reversed that and said, actually, yes, there is. Your Honor,
Because the issue before us is whether there's sufficient evidence to deny the domestic violence protection
correct,
order.
Your Honor. So we believe that there is sufficient evidence to actually grant the these DVCPO, obviously, under.
But isn't the issue whether there was sufficient to deny it,
Correct, yes.
which is different than whether there's sufficient to grant it?
Correct. And so, Your Honor, what we would be asking is either, is really for the court to remand it, for us to be able to have this hearing and be able to grant this DVCPO here.
Wait,
What would it be remanded for?
So, Your Honor, we would ask it to be remanded in a direction to the court to grant the civil protection order.
Okay, you're not asking for a new hearing.
I'm sorry, what?
You're not asking for a new hearing?
No, Your Honor.
Okay, I thought, all right, I
No, Your
misunderstood
Honor,
you.
no. Your Honor, we also are stating, and the second issue is that the court erred in declining to find that the respondent had committed a sexually oriented offense against the petitioner. A sexually oriented offense, specifically in this case, for sexual imposition, that occurs when the offender knows that the sexual contact is offensive. Petitioner testified that there was an incident where the minor child was in the room, and she asked the respondent not to touch her, not to stroke her thigh, and he proceeded to do it. He put all of his weight on her, was kissing her, and eventually she pushed him off. So the other portion of the sexual offense is that there is unlawful restraint, and we are saying that he also committed unlawful restraint, which that occurs when a person prevents a person to when a person knowingly restrains another person's liberty under the statute. Obviously, for that reason, we're asking for that DVCPO to be granted and that this was improperly denied. Moving on to the minor child in the case, the issues are very similar to the minor child. The appellant testified that Apelli actually pinched the child around her, that she witnessed that, and that the child began to cry. The child began to wail in a fashion that she had never heard him cry before, and that she stated that Apelli admitted that he had bitten the child on occasion. Appellant had also testified that Apelli had actually bitten her in the past, so it does, lead to her credibility that he would bite the minor child. And we are, arguing that by doing this, he committed an act of domestic violence against the child by recklessly causing some sort of bodily harm to the child. In addition, domestic violence can be found when a child is found to be an abused child. An abused child is defined as someone, because of the acts of their parents, suffers some sort of physical or mental injury that harms or threatens to harm the child's health or welfare. In this instance, very similar to what was described above, that bite, that prevalence of domestic violence in the household, the child being present when Apelli made sexual advances, unwanted sexual advances onto the appellant. Those are all instances in which the child could be considered an abused child.
That testimony, counsel, came through your client, right?
Correct. Yes, Your Honor.
There was no other source of information but her.
Correct. And I'm trying to recall what questions Apelli answered about the minor child, and I believe the only thing that he stated in relation to the minor child when asked if he had bitten the child or he had pinched the child was no. So I believe that's the only testimony that we heard from him in regards to the minor child. Your Honors, in addition to the things described above, the respondent's abusive behavior was also apparent in texts that he sent the appellant after being served. So after being served with this, he actually contacted a group chat with the appellant and her family in it, her family. Within that group chat, he messaged the entire family, knowing that she was in it, him having admitted on the stand that he knew that she was in it, speaking about the CPO and trying to speak to them about the DVCPO as well.
Was he charged with violating the ex parte order?
He was not, Your Honor. He was not. I do not believe that appellant went to the police with that conduct, so I don't believe that she actually pursued that.
And how does that connect to the elements of the DVCPO?
So, Your Honor, I think it just lends credibility to the appellant. It really shows the pervasive abuse that was going on within the household. This wasn't something that was an isolated incident. This was something that was ongoing, and even, beyond the physical bruise evidence, this was another piece of physical evidence that you could see of domestic violence. Thank you, Your Honors.
It sounds to me like what your argument is that given the details of your client's testimony in comparison to, I think you're characterizing it as I'm going to say minuscule, but maybe that's not of the evidence that was submitted by the defendant, that it is an abuse of discretion to have not granted the civil protection order.
Correct.
Is that in essence what your
Correct.
argument is?
Yes,
All
Your
right.
Honor.
Thank you.
Thank you.
Good morning, Your Honor.
Good morning.
Bear with me while I shuffle one-handed through the papers.
I hope
Todd
that wasn't from
McIntosh.
getting all those freebies at Kroger Wellness.
No, my dog and I had a difference in direction.
They do that sometimes.
They do. She's 1 year old. 1 year old. Your Honor, Todd McIntosh for the appellee, Mr. Shawan. This case is fundamentally about credibility. The appellant cites 22 times in 13 pages of argument the term credibility or credible testimony.
Well, how would you respond to my characterization of the argument, not the characterization, but if that is in essence the argument, that given the quantity of evidence that was submitted and there being sort of a disparate difference between each side of the evidence, that it is an abuse of discretion.
Well, if I may bore the court with a story, my grandfather, who practiced law here in Hamilton County, was a defense attorney, personal injury defense attorney, received a 12-page letter about why he should settle this case, explaining all the facts, everything else. And his response was, "Dear sir, no period, sincerely." The fact is that a no doesn't need further explanation. If it didn't happen, one cannot necessarily explain things that didn't happen. So no is a sufficient answer. It doesn't, the weight of the evidence isn't the amount of time one takes in order to discuss their case or to present their case. In this situation, the paucity of the evidence in comparison, no, is not just it, though. This trial court took its time to self-examine both parties. If you read in the record, he asked her questions, and they gauged her credibility. First, as it was pointed out, she admitted to lying. So here we have someone who is a self-admitted liar. I don't think that adds to credibility. It just means she has no way to get around it.
In what way did she admit to lying? Are you speaking of the doctored photograph?
The doctored photograph, yes.
And how, can you walk me through that? How is that a lie?
Well, it is an untruth in the sense that one presents something saying, "This is true. I have a bruised eye," when it's not true. It's a lie.
And where was it presented again?
This was an incident that occurred prior to court, so this was not presented to the court.
Right.
But both, it was presented as an assertion of abuse. Even the appellant in her brief to the trial court on page 4 indicates that it was, she had modified a picture of domestic abuse to falsify a black eye. So we all understand that this was a falsification of a black eye. That being the very modus operandi that we now have a bruise on an arm as the only evidence that corroborates her story after she's admitted that she will doctor evidence.
Now, the argument from appellants is that the fact that she admitted that she had doctored that photo bolsters her veracity of the remainder, because she was willing to be truthful about her doctoring of the photo.
That's a far stretch. I mean, I understand that I'm willing to admit that I've lied, but it also certainly is the fact that you've admitted you've lied. It doesn't change the fact that you will lie. And if you take that in the construct of the evidence, what we heard before was no real evidence that there's insufficient evidence to overrule the court's decision. The court was in the position to understand the credibility of the witnesses. There's more to this. There's, of course, the doctored photograph issue. The next is that she testified that a pinch was enough to cause a child to stop breathing for several minutes. She also testified that even though she claims the child was bitten, she never took the child to a doctor. There was never a report of a physician, and she never saw that bite or took a picture of that bite. So when you talk about the evidence that would support or sufficient evidence to challenge that credibility where the court would make that decision, there is sufficient evidence to support the court's decision on credibility, at least 3 times, not to mention what we don't have here today, which is, of course, her inflections, her behavior, her mannerisms, all those things that support the trial court's decision of credibility.
So I understand everything that you're saying. I guess my one concern is if you have someone in this circumstance who has lied in the past and has fabricated a photo, does that forever bar her from getting a protective order in the future? Like, we have people in these scenarios who are not always truthful, but that doesn't obscure the fact that there can be domestic violence going on, and how do we as a court system deal with that?
I think you're absolutely correct. It doesn't in and of itself disqualify a witness, but it certainly raises an issue for the court to consider in its weighing of credibility. If someone does that, and I don't know how to do that, but if someone has the experience and capacity to do something like that, and it's the same thing here, I think that raises the court's eyebrow. And then the court goes through the other issues and the fact that there is no other supporting testimony. It adds in. When someone makes a credibility decision, it's not literally the toss of a coin. It's not heads or tails. They analyze the people, they analyze the argument, they analyze the situation. And here we have that analysis resulting in a denial of this order, or application. I think it makes perfect sense that, I'm not arguing that just because someone's lied in the past, they cannot tell the truth. But certainly one must take that into severe concern, because not everyone walks up and says, yeah, I do just this elsewhere.
Counsel, do you agree that if her testimony had been believed, she offered enough to meet the statutory elements for a domestic violence protection order?
Well, the statutory elements are broad, and certainly one does not wish to, I think Lundberg Stratton said it best in Parrish, the court really needs to take into consideration, because this is such a pervasive and very, very serious issue in our society, that the court should make every effort and should pay attention to those issues. But once again, it shouldn't forget that there is someone else on that other side who may not have done that act. So whether or not, had she been believed, she would have made it, wasn't really the issue with the court. The court decided she was not credible, that evidence did not weigh. The only, the only other thing I wanted to point out, there were all of it related to credibility, except for only two things in her argument. The one she related to, that is appellant's counsel, the WhatsApp posting. And as you aptly pointed out, he wasn't charged with it. That doesn't set an independent standard. And actually, in Bay versus Rosswaller, the Ohio Supreme Court, 2020 Ohio 3301, found that posting to a public website or to an open website is actually a prior restraint, that it wouldn't provide a foundation for the granting of a TPO, or a civil protection order.
Well, but I think posting, and forgive my technological lack of knowledge, but sending a message to WhatsApp is different than posting something on
Correct.
the website.
It didn't address WhatsApp, right? WhatsApp is a chat room more than
Well, it's essentially a text function.
It is essentially a text function.
Yeah.
The fact that he was reaching out to his mother-in-law, and that she was a potential viewer of that, I think that Ray addresses that to some extent. But fundamentally, she concedes in her motion to the trial court, and we know that that's not a basis for the granting of the TPO. I just wanted to touch on it because it was the one non-credibility issue that she had brought up. That's all I have. Thank you very much.
All right, thank you.
Your Honor, Sierra Kazi for appellant again. I did want to address a few things that were mentioned in Appellee's brief that he didn't necessarily mention in his argument and respond to those things.
Can you answer first, like, did the child ever get medical attention for these alleged attacks on him?
So let's talk about the bite first. So the appellant did not know about the bite until the incident of the pinch, where appellee told her and had informed her that he had bitten the child before. She had no knowledge of that and didn't know about that. So obviously she did not seek medical attention at that point. After that bite, what the appellee...
But I mean, if it were a real bite and something that caused the child harm, wouldn't she not have known about that? Wouldn't the child have said, I'm hurting or something?
Well, the child, I mean, at the time, the child would have been too young to be able to speak or report
I forgot
it.
the age.
Right, so he would have been too young to do that.
Okay.
And I can't speak on the occurrences of the bite because obviously she wasn't present, she didn't know about it. That wasn't really gotten into a testimony because it wasn't explained when the bite actually happened, when he told her. As for the pinch and answering your question on that, appellant was actually in the past prohibited from leaving the house unless she told appellee where she went. She testified that she was unable to leave unless she told him, that he would restrain her from going, that he would grab her, pull her back into the home. And so what she did was she actually over that weekend went and filed a civil protection order to protect herself and the child. And she thought that was the best use of her time at that point. Your Honors, talking a little bit about the self-serving testimony that appellee asserts that appellant gave, he cites In re Rios and Lozada v. Lozada. In re Rios, what happened was that a self-serving affidavit with no other competent corroborating evidence or testimony documents any other probative facts were presented. And obviously, that's not the case in this situation. She did present her self-serving testimony, which was her own testimony, but she also presented pictures. We also heard, utterances from the appellee that cited that he had, grabbed her before. So I believe that using that just doesn't really apply. There was more than just self-serving testimony in this. And in Your Honor, Durasante versus Durasante of this court actually said that testimony of abuse and can actually just be enough to say that the respondent actually recklessly attempted or recklessly caused bodily harm. In that case, that they did not find that a DVCPO was going to be granted because the petitioner's testimony was so inconsistent at the trial. But in our case present here, there was no inconsistent testimony. The petitioner was very clear. She was very concise about what had happened. She was never going back on her word. She was never changing her story. She was very consistent. She stuck to her story, very similar to the petitioner in Felton and very similar to the petitioner in Durasante versus Durasante. In Durasante, the court said that if she had been a credible witness and paired with that photo, that would have been enough. That would have been enough for them to grant a DVCPO. Thank you, Your Honors.
Thank you. Thank you for your argument. Thank you both for your arguments this morning. We'll take the matter into submission and issue a timely decision. Have a wonderful afternoon and a great week. William Chappell versus Wheeler Growth Company, et al. Good morning.
Good morning.
How are you doing?
Good, how are you?
I'm good, I'm good. You want to speak up so that we can hear you well, okay?
I would like to reserve 3 minutes, if
3
that's
minutes,
okay.
all right.
Good morning, and may it please the court. At the end of the day, this case is about a tree and a finding of actual malice that we believe is improper. Actual malice was defined by the appellee in their brief as behavior characterized by hatred, ill will, or a spirit of revenge, or a conscious disregard for the rights and safety of others. That has a great probability of causing substantial harm. This definition is very important because in this case, there was no disregard for the rights and safety of others. They've defined actual malice that you need both disregard for rights and safety.
But the trial court found that your client did act with actual malice and kind of set forth the series of lies and other actions that substantiated that. So what are we supposed to do with that?
So while there was some discussion at the trial court about lies, the important factor is that none of them go to a disregard for the safety of others. There was a retaining wall in this case that was in the
I'm sorry, I want to stop you there. Are you saying that you can never have an actual malice finding unless someone is physically harmed or might be physically harmed? Is economic harm not enough?
So the definition that has been used is for the rights and safety of others. And while there is economic harm, in comparison to the harm that could have resulted if nothing was done, that's fairly insubstantial. The retaining wall was in the process of collapsing. It was keeping one property above another property. Had it been allowed to continue to collapse, the upper property would have slid down into the lower property. That would have been a much greater economic harm, if not a physical
Right,
harm.
but to get back to my question, economic harm is or can be sufficient to establish malice, right?
Correct. There is a factor of economic harm. Okay, so
But are you saying that that goes towards the portion of substantial harm?
yes, even the economic harm that was found, ultimately it was found that appellant was responsible for the value of that tree, and we don't disagree with that. There was a tree that, a better arrangement between the two parties could have been reached, and ultimately he did not have permission
For
to.
clarification, because a finding of malice is just, getting to the end result, right? On what basis did the trial court determine that there was malice?
So the trial court found that because.
In other words, let me ask it differently. Was it on hatred, ill will, spirit of revenge, or the conscious disregard of the rights and safety of others?
They found that there was a conscious disregard for the rights. We disagree that there was any disregard for the safety of others.
Was there any evidence submitted that went to safety at the trial court level?
There was extensive testimony at the trial court level that had the retaining wall been allowed to collapse, that would have resulted in one property sliding into the other, which would have been a safety concern.
Right, but with regard, and let me re-ask the question, with regard to the taking down of the tree, right, because that's what this is all about. Now, I know the rationale as to why, okay, but with regard to the taking down of the tree, was there a determination that that was a disregard of the safety of others?
No. The tree.
And was there any evidence that with regard to the safety of others in relationship to the act of the taking down of the tree?
I'm sorry, I don't believe I'm understanding the question.
Okay, so you're saying that both need to be met, right? The disregard of the rights and then the safety of others, right?
Correct.
So I'm asking you, was there evidence with regard to the safety of others for that portion of it that was
So-
submitted at the trial court level?
Yes, there was evidence that had the tree not been cut down, it would have impacted the safety of others.
So that really goes not against your client, but in
Correct,
favor of your client.
correct.
Okay, was there any evidence that went against your client with regard to a disregard of the safety of others?
No.
Okay.
There was an arborist expert who testified at trial, who testified that the roots of the tree were growing underneath the retaining wall and actually contributing to its collapse. So had the roots of the tree been cut in order to repair the retaining wall, the tree likely would have died and fallen. At the same time, the tree was also leaning towards the house of Mr. William Chappell, and so had the tree roots been cut to a significant portion that would have caused the tree to die, the tree likely would have fallen towards his house.
Is this issue briefed this way in your briefing? Do you specifically address the safety component? I know you've raised actual malice as a question, but have you argued the case this way in the briefing?
Yes. We did discuss in the briefing that if the retaining wall fell, that would have resulted in a safety concern for many. There's also reference to the tree falling towards the property, which would have been a safety concern. There was also initially a garage on the Wheeler Chapel, or the Wheeler Growth property, that was removed as a safety concern. As the wall began to collapse, the garage started to collapse as well because it was no longer being properly supported. And so that was removed and that's referenced as well.
That's getting to the safety concerns that exist with not removing the tree. But what I understand you to be saying now is that there was not any evidence that your client consciously disregarded the safety of Mr. Chappell in order to meet the actual malice standard. Is that something that you argued in the briefing?
I'm sorry, can you rephrase that?
Yes, we're focusing in on the actual malice standard. And what I understand you to be saying today is that there's two components of that conscious disregard piece of the standard. One deals with rights, one deals with safety. And what I hear you to be saying today is that the trial court focused exclusively on rights and didn't talk about safety. And today I hear you to be saying that there's not any evidence in the record that your client consciously disregarded Mr. Chappell's safety. And that's what I'm asking about in the briefing. Is that in the briefing?
Yes. We're using Mr. Chappell's definition of actual malice, which references the safety. So then in the reply brief, we extensively discussed basically accepting his definition of malice. Even if we accept his definition of malice, then there has to be an element of disregard for safety.
Well, I guess I don't understand that because it seems to me like you're citing essentially the same definition in your brief, but I'm looking through your brief right now and I don't see an argument that you're making today that there is some requirement that the victim's safety must be imperiled. So is that in your opening brief?
No, we used a different definition in our opening brief.
Okay.
We used the conscious disregard for the rights of others, as well as there has to be a mental intent as to they were aware of what the harm would result.
Okay.
And did you make the argument at the trial court level in arguing against malice?
Yes. At the trial court level, there was testimony as to the collapse of the tree, and that there was no disregard for the safety, again referencing the potential collapse of the garage, as well as if the tree were to fall on the property.
I guess I don't understand, like, and maybe this is just hindsight, but if he wasn't giving permission to remove the tree, why didn't your client just say, okay, well, we can't fix the retaining wall and it's going to collapse onto your property? Like, that's on you if you don't agree to have the tree taken down. Like, wouldn't that have been a solution here?
So there's also the aspect of this was not the only property on that street that Wheeler Growth owned. They also owned a neighboring property that had a retaining wall with a similar circumstance. In that situation, they were ordered by the city to repair their retaining wall so that the fellow property could repair their parking lot. Through that, Wheeler Growth communicated with the city of Cincinnati. There was a witness, Emilio Voltaire. He was an engineer in the building department for the city of Cincinnati. And through there, Wheeler Growth was under the understanding that the city of Cincinnati could require that these things be done. That's where.
But I think that's what looks kind of more debatable based on the email or text correspondence that we see in the record.
Yes, there is room for debate on that.
Yeah.
But ultimately, with the the email correspondence that you referenced, we also think that that is a great indicator as to the actual mental state and the actions of Wheeler Growth. In there, Emilio Voltaire referenced that he initially reached out to Mr. Chappell in order to get permission, in order to pass along his phone number to Wheeler Growth. At the same time, that email chain explicitly shows that Wheeler Growth provided that phone number to Emilio Voltaire. So the credibility issues throughout this case were a contentious factor, but at the same time, that email shows that it's not just Wheeler Growth that I don't want to say lied, but this case took on a 3-year time frame. And
Right, and can you address the attorney's fees?
Yes.
Because as I understand your challenge to the fees, one, you're saying it's duplicative, and second, you're saying there's a lack of proportionality. And on the duplicativeness, as I understand what you're arguing, you're saying, well, 2 attorneys were doing something. And I hear that, but isn't that how attorneys often work? Like, you have a junior attorney, you have a senior attorney, and they allocate responsibility accordingly. And that doesn't mean that they both don't review the same document or participate in the same phone call. So where is the duplication?
The duplication is in conjunction with the proportionality. At the end of the day, this case was about a $300 tree, and there were multiple attorneys on the case doing the same thing. When we have a $300 tree, we also have to look at the proportionality of the damages in relation to the attorney fees that were accrued. This is a...
Right, and so I've not been able to find a single case in Ohio that has struck down an attorney fee award simply because of proportionality. Have you seen anything?
So there is Wing Leasing Inc. versus M&B Aviation.
Yeah, but that's just dicta because they reached the holding on an alternate basis.
Yes. We still find it to be persuasive considering the amount of money that was recovered for the plaintiff in relation to the attorney's fees. The attorney's fees were considered to be completely unproportional.
Well, but so if we agreed with you, what would we say to the trial court? Would we say, these fees are too large, reduce them, and then the trial court says, well, what am I supposed to do? Like, and that's the problem that I see in these cases talking about proportionality is they don't want to require a specific ratio because of a variety of reasons. But then, like, what guidance would we give the trial court in that scenario?
So that's where we made the argument in our brief that because they're duplicative, reasonably, then we should cut that attorney fee in half. If they had excessive amount of efforts from attorneys to recover just for the minimal recovery of a $300 tree, a good place to start would be with that 50% reduction. So with this as well, I would like to go back to the...
You have about a minute.
Okay, thank you. I would like to go back to the lying factor. It was talked about a lot at the trial level that Wheeler Growth's representative had lied. As to that, a lot of the lies that were talked about were after the tree had been removed. We think it's important to remember that a lie after the fact does not mean that there was malice in the commission of the Tortious Act. The Tortious Act in this case was the removal of the tree, as ultimately it was determined that Wheeler Growth did not have permission to do that.
But the cover-up's always worse than the crime. Like, why isn't the cover-up, if it is a cover-up, probative of malice beforehand?
Because it doesn't... Let's talk about an example, and cut me off if I run out of time, please. If someone runs off the road and runs into a stop sign, and then when the police ask them if they ran into the stop sign and they say no, it doesn't mean that they had malice in running into that stop sign. It means that ultimately, after the fact, they realized something wrong had occurred and they were potentially trying to cover up for that. At the end of the day, there has to be malice in the commission of that tortious act, not just after the fact.
Thank you. Good morning.
Good morning. My name is Christopher Finney. The first time I think up here in front of each of the three of you, maybe the second for you, Ms. Zias, I'm not sure, Judge Zias. But if it please the court, first of all, go to the prior oral argument that you had and you properly cited, and was really no discussion of the very contradictory view of the parties of the standard of review here. Clearly, it's an abuse of discretion standard of review. There were two cases or two concepts cited by the plaintiff, or the defendant in this matter, the appellant in this matter. One was a defamation standard awarding punitive damages, saying it was de novo review. This is not a defamation, and that decision specifically referred to defamation cases. And the second time, sort of strangely, she said in a directed verdict situation, it's a de novo standard. Well, this was a full trial. So from our perspective, there's no question that this is an abuse of discretion standard review. And then, interestingly, when you go to the abuse of discretion standard review, this court is in the position where it should follow Fox v. Williams, where the court said the trial judge is best able to view the witnesses and observe their demeanor, gestures, voice, and inflections, and use these observations.
While I understand that, one of the arguments this morning is that there's an element missing.
Okay, well, that's a fantastic question, and Judge Bergeron.
If there's an element missing, then
Oh, no question. If there's a clear error of law, that would be a separate basis. Unfortunately, as Judge Bergeron.
that would result in an abuse of discretion.
You're correct, Your Honor. And as Judge Bergeron narrowed in on, it's the very first time that's been argued. It wasn't argued at the trial court in any way, shape, or form. It wasn't argued in the opening brief, and it wasn't argued in the reply brief. So this notion, which is incorrect as a matter of law, has been waived. But let's just talk about it for a second.
Yeah, I mean, what I understood her to say is that there is a legal requirement that there be some jeopardy to the safety of someone to constitute malice, and but I didn't see that being briefed that way.
Yes, and just to clarify, we made no argument at trial, and there was no evidence introduced at trial that Mr. Chappell's safety was at issue, the question that Judge Kinsley was asking. That wasn't part of the facts presented, and it also wasn't part of any argument presented at the trial court or any briefing up until now here. But let's just say you didn't accept that it has been waived. It's wrong as a matter of law. There is no support in the law that you have to have both an impairment of property rights and physical safety of the plaintiff to be at issue. It's the first time I've heard of that, and I don't believe that's what the law provides.
She's using this outside. I mean, if there's a determination of hatred, ill will, spirit of revenge, then it does not require the determination of the conscious disregard of the safeties. It's only
Correct.
when it's only when malice is determined based on the conscious disregard of the rights of others that it also is accompanied with the requirement of the conscious disregard of safety. That's what her argument is, as I
Correct,
understand.
and that is novel both in terms of, as I understand, Ohio jurisprudence, but novel as far as this case is concerned because it was never argued until I heard her stand up here today and say that for the very first time. So I've never heard that argument before as a defense to Judge Ruhlman's very specific ruling on that.
What was the definition of malice that was used by the trial court?
It's set forth in paragraph 3 of his decision, and he says, first of all, and I think it's important, there's been some discussion here today about we didn't show that Haskamp, the manager for Wheeler Growth, lied before the tree came down. Utterly untrue. There was tons of evidence. I'm sorry, I didn't want to use the word lie. Was lacking in candor as the case went forward, as the matter went forward. But what he found was there was a positive element of conscious wrongdoing and actual malice, and by Wheeler Growth's actions demonstrated a conscious disregard for the rights and safety of plaintiff William Chappell that had a great probability of causing substantial harm, citing Preston v. Murtry and Malone v. Courtyard by Marriott.
So if the trial court determines that there's a conscious disregard of the rights and safety of others, and that was not argued, but yet the trial court determined that, couldn't the appellant then argue at the appellate level that there was no evidence to support a determination that there was a conscious disregard of the safety of others?
I suppose, well, I think they waived at the trial court level, but to assume they didn't, they could have argued it in their opening brief. And
Well, if it was
not
not
to
argued
do
by
that.
either party and yet the trial court used that to make a determination, right?
That was the standard we presented to the court, and they adopted it. I will say that at the trial court level, the defendant, the appellant here, consistently wanted to changed the topic to hatred and ill will. And so if you read their closing argument, if you read anything they said during the trial, they focused on the fact that there was no bad blood between the parties. They never discussed the conscious disregard standard. And as to the conscious disregard standard, if I might, I want to make sure that I know Judge Bergeron has read it. I think maybe one of the others of you have referred to this also. But before the tree came down on May 22nd and May 23rd of 2019, Mr. Haskamp, the manager for Wheeler Growth, wrote to the city building inspector. He, by the way, she said he's in the engineering department. He's not. Emilio Voltaire, as the testimony showed, was in the building department. He's a building inspector. And he said two things. He said, Mr. Chappell refuses to let us take down the tree. And he said, can you, the city, help us get him to act like you made me? He wanted him to lie to him. So, and then we had 4 separate text messages from the contractor called Millstone to Mr. Haskamp saying, do you have permission? Do you have permission? Do you have permission? And every time he dodges the question. So when she says there was no testimony before the tree came down that shows this conscious disregard, it's just untrue. There was ample testimony, so much so that the judge volunteered multiple times in making his decisions that Mr. Haskamp had lied.
So Attorney Finney, you represented at the trial court level, is that correct?
Please?
You represented at the trial court level?
I did.
Okay. What was the argument that was advanced with regard to why there was malice? What was the
conscious disregard standard? There was a
you
positive.
So you did not advance anything with regard to hatred or will or spirit of revenge?
We did not, and we did not make any argument that there was any danger of Mr. Chappell's personal safety, because we didn't think that those were required, and because that the standard of actual meaning of hatred and ill will didn't apply. We didn't suggest that it applied. What we suggested was that Mr. Haskamp, who was a licensed attorney, a realtor, a property manager, had knowledge of the law that he wasn't allowed to take down Mr. Chappell's tree without his permission. He knew about that, and he tried every way he could to work around that issue instead of getting the permission that was required. That would give us exactly, which is what we tried, that conscious disregard, that knowingness that he was evading the property rights of Mr. Chappell.
And so, can you address the attorney's fees for a little bit? Because I think as I look at this, I mean, there is a substantial contrast between the amount of fees and the amount of damages that were obtained, which is troubling to me, because, and I don't mean to suggest that you could never exceed the amount of damages, because then attorneys could never pursue small dollar claims. But there is a difference between making sure that an attorney is compensated for pursuing a small dollar claim and going beyond and beyond and beyond. And can you address the proportionality issue here?
Absolutely. I appreciate the opportunity. First of all, as your honors may be aware, I do a lot of public interest litigation. And in many times, say in a First Amendment case, you're entitled to $1 of nominal damages, and then you're entitled to an award of attorney's fees. And we hear this all the time. They got $1 for their client and $1 million for themselves. That's the way the law works. And the question is one of the lodestar, which is a simple mathematical formula of hourly rate times hours reasonably expended to get to that conclusion. Now, the proper analysis to me is not a proportionality analysis. The proper analysis is that reasonableness question. Is reasonableness constrained by the amount of the damages? I don't think it is. I think that you do what you have to do to get a case to trial. And in this case, and Judge Ruhlman specifically on the record, not in his entry, but on the record said that the fees in this case were multiplied by the hiding of the facts and the prevarications by the defendants here. And if you look at what we did at the trial, of how we had to prove affirmatively that what Mr. Haskamp, so Mr. Haskamp came forward, we filed a complaint, and his answer said, I had consent. Okay, you hadn't consent. Now I have to go about proving the contrary to that, proving a negative, you didn't have consent. And fortunately, there was a trail of witnesses, text messages, and emails which I've shared some of them with you today, that show that not only was he not telling the truth about the fundamental trespass issue, but that he had a conscious disregard.
But it comes down to reasonableness. So as I understand it, there was no challenge on the rate amount.
Actually, Your Honor, if I could, so on the lodestar question, there's 3 components to determining fee: hourly rate, reasonable number of hours, and expenses that are incurred. They didn't challenge any of those things, really. At the hearing on fees, we presented precedent where my fees specifically, and a study that was adopted by the federal district court, I think in the Wendy's International case, if I recall, established fees. They didn't challenge in any way hourly rate.
And
they didn't
I
challenge.
think their expert, I recall his testimony being very brief and not addressing the reasonableness factors.
Correct, and I tried to pull it out of him. I said, what would you do differently? Just
Right.
give us something. And he said, I wouldn't have done anything differently.
Counsel, didn't you have to seek third-party discovery from the city through public records? And then this was a 4-day trial, and you were in discovery disputes with...
It went on and on. There were 5 different trial dates. On every one of those trial dates, we asked the defendant, will you consent to giving service to your clients, meaning the Wheeler Growth owners, so that we don't have to argue authority? He never responded to any of those. So 5 different times we had to subpoena their clients to the trial. 19 communications were necessary in order to get Mr. Haskamp's deposition. Once we set Mr. Haskamp's deposition, they filed a motion to quash. We had to go over and talk to Judge Ruhlman about the motion to quash. All of that necessary to get one deposition. So it was a tortured proceeding from day one, and I call it the little old lady always loses. You saw that in my brief. What does that mean? I'm a neighborhood attorney. I counsel people all the time who come in and something bad has happened to them. And I tell them day after day, you can't afford me, don't hire me. You can't get justice over at the courthouse. And they leave in tears. It's horrible. And that's what they're saying. They're saying with a proportionality test, if we throw, and remember, the client was an attorney and you had an experienced attorney defending, and they made a decision that they were going to make this very difficult. And by the way, they demanded a jury trial all the way from beginning to end. We wrote jury instructions. They never wrote any jury instructions at all. They didn't submit any, but they demanded a jury trial. They then objected to our jury instructions, which we had to argue in front of the judge. And then at the last minute, the very last minute, literally 5 minutes before we walked into trial, they waived the jury. And what did that mean? I had an audio-visual expert with the whole presentation ready, the preparation, the AV costs, all of those things. And 5 minutes before we walked into trial, they said, never mind, we don't want a jury. So they made a conscious decision to run up the cost. And that little old lady who comes into my office, and every week I have this conversation with a client. I'd like to help you. You can't afford what it's going to cost to get your $10,000 or your $20,000 back. Mr. Chappell, who's here in the back, it was a contingent fee arrangement, but he's responsible for those $17,000 of expenses. And so when you say proportionality, the reality is what you're saying is people like Mr. Chappell cannot afford to get justice in your courtroom. That's what you're saying. Because there's no law, and that's what Mr. Gay said. Mr. Gay, their expert witness said, you just got to take it. And basically what he's saying is you have to turn these kinds of clients away. They can't afford to wade through the system to get justice in this courthouse. That's what proportionality means to me, respectfully. Thank you all.
Thank you.
I just have one last thing that I would like to touch on. It has been talked about in this case as well as the earlier case this morning. It seemed like we had a common element of lying. And one thing that was mentioned is that the trial court is at an advantage as to perceiving the dispositions and demeanor of witnesses. At the same time, in this case, even if we believe that Justin Haskamp, the representative for Wheeler Growth, to be dishonest, at the end of the day, we still only have to look to his actions as to what his mental intent was and as to his regard for others' safety. He removed a garage so that it didn't collapse. That garage, the Wheeler Growth property, is a rental property, and that garage added significant value to the property. But he removed that for the safety of others. The same thing with the tree. He paid to have that removed, and it was to prevent it ultimately from falling toward the Wheeler, or the chapel property. Thank you very much.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Have a wonderful afternoon.